So hi guys, I'm back with another new video of self-talk. Actually, it is technically not technically a self-talk, but apparently it looks like more of what I would say podcast, single podcast because I am giving a speech and you all guys are listening it. So talking about my day today, whatever I have done, I will narrate you. So in the morning there was a huge, there was like raining cats and dogs. So it was quite difficult for me to go outside to to go towards the court uh, where I am doing the internship work. But after some time the rain stopped. I went. So I went by metro only. Firstly, I was thinking to go by auto, but touchwood the rain stopped, so I went by metro only. So yes, today it was very nice experience. It was a very good day for me because the judge ma'am whose under I am interning in, she actually appreciated me for my work, whatever I have done for like research work and all, and whatever she put question before me, I thoroughly answers them all because I am also preparing for judiciary. So pretty much I know the procedure, whatever is whatever the mechanism of the courtroom, how it works, how it functions and all. So this is one thing, and then ma'am ordered some pakoras, and also we had them together because ma'am invited me, and it is a monsoon day. It was raining, so she said ki it would be nice ki we would eat pakoras, and also very great feeling was someone you admire, and at a post where you dream of, and someone is sitting there and he is like making you feel special every time. Or she is actually, there is a courtesy, there is some courtesy when someone is working in front of you or under you. You have some courtesy to acknowledge him or to entertain him. So she entertains me well, like for every she teach me and explain me every small thing. She educate me with or she educate me on some very burning issues, or on some very technical topics that as a law student or as a judicial aspirant I should know. So this is one thing, and then after having the my done my internship work, I came to coaching. So there was constitution class going on, in which we have studied the amendment power. There are three types of amendments: special majority, simple majority, and a special majority plus ratification by states. So in the case of simple majority, any amendment can be done apart from Article 30, and it will not come under Article 368. Mm. So actually, there are some types of amendment which comes under the purview of this. So first is that citizenship, or Article 124, territory, state territory or state, you are altering the boundary of a state, renaming the boundary, or creating a new state, and all this is a and given in Article 124. And these things can be amended by a simple majority. And then comes the special majority, which deals with the amendment of the what fundamental rights and all, fundamental rights, the PSPs and all other things that did not come under a simple majority. And so after there comes a special majority plus ratification by states, and there it comes the amendment of Article say 368 itself, Article 79, powers of governor, appointments of governor, president, and all these things. Dot dot dot. And then I attended the class of Hindu law. So there we are studying the Sapinda, we were studying the section, yes, section 11 was a void marriage, and section 12 voidable marriage. So actually in section 5 they provides for the conditions of marriage which will be considered as valid. So it should be solemnized, and both should be Hindus, and it says to satisfy all five conditions given in that provision. So first is both parties should not be married, And so and second thing, it is body should be of unsound mind. Third is of age. Fourth is of prohibited degree, and fifth is of sapinda. So if you infringe or violates provision uh, 1, 4, and 5, then it will be called as uh, void marriage. So it will come under section 11. And if you infringe why I'm saying articles every time. So anyways, if you infringe section 2, like provision 2 of section 5, then it will considered as completely void marriage, because it is of unsound mind, sorry, voidable marriage. And then this is this is the thing. And there are also some more conditions to make the marriage as voidable marriage. Actually, it is upon the one party to declare it as void. And there are some grounds which says that you can make the marriage void if the other part, one of the spouses, impotent. So after you know the other spouse is impotent, there is a limitation period of 1 year in which you can file the suit for uh, to 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 make the marriage void, to null and void, to declare the marriage null and void. And then there is a ground of pregnancy, like if the wife was pregnant already in the time of marriage, then you have to file the suit within a year of that the marriage. And coming back to the uh, impotency part, if you know that other partner is impotent, then you are living happily with full consent, then you cannot give you cannot press a suit, you cannot institute a suit regarding that. And then section 9 talks about the restitution of conjugal rights, which is the restoration of your conjugal rights. Conjugal rights are basically the rights which are the conjugal rights are the rights which means you have the right to enjoy the company of the other partner. So if a wife or a husband or any spouse separates from the other spouse without reasonable ground, or separates from the community of the other, then you can file a suit for the restitution of conjugal rights. And if you get a degree of restitution of conjugal rights, then you have to show to the other spouse, and he has to return to the workplace where marital to your marital home where you are living there, wherever you are living after marriage. So this is RCR. And yes, so it is actually the law behind the burden of proof is that whoever going to court has to prove the guilt of other party. So but then this is the exception. And this is the exception. If someone is separate from the society, he have to prove it, that person himself has to prove it, he has not separated from the society. This is the thing regarding Hindu law. And then I attended the class of BSA, in which class, and that class sir was teaching the dying declaration, which is given in article section 26A of the Indian evidence of the Bharati Saksha Adhiniyam. And before that he talked about article section 25, which is when admissions are not conclusive proof, which means you can rebut the statement or admission with a contradictory evidence. It is not a conclusive proof, therefore. And then dying declaration, so it is basically a statement which the person made, uh, has yeah he has or has not anticipated he has or has not have apprehension of death. And it talks about that statement which is given orally or verbally, talks about the what it talks about the cause of death or circumstances which resulted into the death. So this is the thing regarding dying declaration. And then coming towards the BNSS class today, that I watched in the recording itself. There the sir was teaching the section 223 of BNSS, which deals about the complaint. So if you are filing complaint, then you have to file it in writing. or orally also it can be done. Then magistrate will examine the complainant and other two witnesses and then issue recognizance notice to the accused person. But in the case of public servant, if public servant is filing the complaint, then complainant should need not be examined, and it should be the magistrate can directly take the cognizance after hearing the accused. If the public servant is the accused, then they do not, then the complaint cannot be filed against them without the without giving them opportunity of reasonable opportunity of being heard. So this is the thing that sums up my today's sessions and classes. So it is a fruitful activity because I have revised all the things whatever I have studied today. So it is a good thing. Like, okay, thank you so much. I will meet tomorrow definitely. Let's call it a day. Bye bye. Take care.